Hello, everybody. Welcome to today's webinar, Probate, a Step-by-Step Guide. My name is Paula Price. I'm with the People's Law School. I'll be your host and moderator today. We've got two incredible guest speakers, Jasmine Ng of the Vancouver Law Courts and Jessica Poon of West Coast Wills and Estates, and I will be introducing them in just a few minutes. Now, you know you're in the right place if you've got questions about probate. As the title of this webinar describes, we are going to be navigating or talking about probate and in a step-by-step framework. And what that means is we'll be talking about the pre-probate steps like locating the will and deciding what process is required. We will be talking about the probate application itself, and then finally distributing the estate assets and wrapping up. What you can expect today, we have 60 minutes together. We will be providing answers to common questions about probate and the estate administration process. We are going to be sharing legal information, not advice, and it's current as of today. Now, if what you're looking for is legal advice, so the law as it applies to your particular set of circumstances, then we would invite you to reach out to a lawyer. You're welcome to reach out to Jessica or a lawyer at her firm. The contact information is on the screen. You're also welcome to reach out with any questions you have about the probate process to the Vancouver Probate Registry. The number is on the screen as well. We would like to acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we invite everybody who has joined us here today to reflect on where it is that they are joining us from. We'd also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes production of these webinars possible. And finally, we would like to thank and welcome our speakers for today's webinar, starting with Jasmine Ng. Jasmine is the Deputy District Registrar and Registrar in Bankruptcy of the BC Supreme Court. She is currently located at the Vancouver Law Courts in the Probate and Bankruptcy Department. Jasmine will share the probate and administration process from the perspective of the court registry. We are delighted to have Jasmine. Jasmine, welcome to today's webinar.
Thank you very much, Paula.
We also have Jessica Poon. Jessica is a lawyer with West Coast Wills and Estates in North Vancouver. Her current practice focuses on family law and estate planning and administration. So she assists clients preparing wills, trusts, powers of attorney, representation agreements, and assists with probate and related matters. She's fluent in Cantonese, speaks conversational Mandarin, and she often presents to the public about all things to do with estate planning and probate law. So we're delighted to have Jessica with us as well. Welcome, Jessica.
Thank you for having me.
It is a pleasure. Thank you. So with that, we're going to dive into our questions. And the first question is for Jessica. Jessica, my father passed away. I think I'm the executor. What's the first step?
Yeah, so the first step is to locate the will. You should look around places where the deceased person usually kept their important documents, both physically and electronically. So this would mean looking around the home, filing cabinets, safety deposit boxes, and also on electronic devices like computers, laptops, and phones as well, smartphones. You can also do a wills notice search to see if the deceased person has ever registered a will with the wills registry. And this can be done with vital statistics. If the results come back stating that a will has been registered, the location of the will would be indicated on there as well. Now, the location may not always be up to date. Oftentimes people move the will from one location to another and forget to update the wills registry. So it is a good tool to use, but not always the most reliable. I would also like to point out that if you are named as the executor, or if you think you're named as the executor in a will, before you start acting as the executor, you should consider whether or not that is something you want to do. It is a huge it's a huge responsibility to be an executor. And just because you are named or appointed in a will does not mean that you have to do it. You are allowed to decline the appointment by renouncing as executor. And it's important that you consider this early on in the process, because that renunciation should be done before you start dealing with the estate assets and intermeddling with the estate.
Beautiful. Thank you so much, Jessica. Which leads us to our next question. What is the first thing an executor should do?
Yeah, so something that happens pretty quickly after somebody passes away is the funeral, of course. The executor should handle the funeral arrangements, and if there are specific wishes in that will regarding a cremation or a burial, if there is something indicated, the executor should follow those wishes. The next thing to think about is the estate assets. So as the executor, your job is to protect the deceased person's assets. And this means making sure that there's no loss or damages caused. For example, for homes and cars, those should be locked up and secured. Valuables in the estate, jewelry, that kind of thing should also be stored in a secured place. Insurance is something to think about as well for major assets, home insurance, car insurance, making sure those coverages are still, the insurance policies are still valid and sufficient. It's a good idea to talk to the insurance company just to make sure that the coverage has not expired, or that the death of the owner does not affect the policy itself or the coverage. The other thing to think about is the deceased ID cards, and make sure those ID cards are kept safe, making sure nobody can be using the ID. It's to prevent identity theft. Banks and financial institutions should be notified, again, to make sure that nobody's accessing those accounts without the authority to do so. And then the government body should also be notified. So Revenue Canada, CRA, Service Canada, and even Canada Post if you need to redirect mail, making sure that the mail doesn't go to a vacant home or a rented home. And then when you notify Service Canada, the executor should also apply for that CPP death benefit.
Super. Thank you so much, Jessica. Another question for you, which is, do I have to apply for probate? Can't I just deal with the banks without the hassle and delay of applying for probate?
So the probate application is only really required when someone asks to see an estate grant from the court. The estate grant is what you get at the end of that probate application. It's essentially proof that you are the personal representative of the estate and that you have the authority to deal with the estate. So when I said it's required only when someone asks to see it, who I'm talking about really is third parties like financial institutions, ICBC, the Land Title Office, other institutions to say, how do I know this? You are the person who is appointed, who has the authority to deal with the estate. For financial institutions, for banks and ICBC, the general threshold is $25,000, but it is ultimately up to that institution. So if you're dealing with the bank accounts, with a bank and the total value of the assets in that bank is less than $25,000, it is likely that the bank will release those funds to you without, to the executor without seeing the estate grant. Again, it is up to the financial institution, so you should be asking questions. ICBC, same thing. The general threshold is $25,000. So if the car is worth less than $25,000, chances are ICBC will allow the transfer of the car without an estate grant. If there is land in the deceased person's name only, the probate application will definitely be required. The Land Title Office will require the estate grant before they allow anyone to deal with transferring land from this deceased person's name to anybody else. If there are assets in the estate that is worth more than $25,000 or land that is held, if there's assets in the estate that's worth more than $25,000, but they are jointly held with a spouse, if they're held in joint tenancy with the deceased person's spouse, That asset, that bank account is passing to the surviving spouse outside of the will. Probate will not be required. Same with land. If land was held in joint tenancy between the deceased person and their surviving spouse, the land will pass to the surviving spouse automatically without probate. There are registered accounts and pension plans and insurance policies, products where you can designate a beneficiary. If you have designated beneficiary through the financial institution or the plan provider, the person you've designated as the beneficiary will receive the money outside of the will. So again, if the will maker had designated the beneficiary on their RRSP, for example, that money will go to the designated beneficiary without requiring probate.
Beautiful. Thank you so much, Jessica. You've outlined a number of the different thresholds and situations where probate is and is not required, and that's very helpful. And I think that term you use, passing outside of the will, that refers to things like the designated beneficiaries, the land that is held in joint tenancy. They're simply excluded from the concept of the estate.
That's correct.
Wonderful. Thank you. Jasmine, this next question is for you. And the question is, who do you need to notify when you apply for probate?
Yeah, so definitely without giving legal advice here, I unfortunately would not be able to tell you who you would need to notify. Just because every application is different and different individuals are at play for each application here. So it really ultimately comes down to perhaps the beneficiaries or any persons who notice must be given to that should be notified. In the Supreme Court Civil Rules 25-2 sub 2 does have a list of the people that you may need to give notification to. Otherwise, I would then suggest you to speak with a lawyer who can give you a better indication of who you do need to notify. There is one resource that we often do let our self-represented litigants know, or even clients, is that there's in chapter 5 of the Probate Kit by Mary Jane Wilson. That's a really great book. It has a lot of information on this topic, and it's often a resource that we give out to a lot of our clients when they do need assistance on, who to notify and how to do so.
Beautiful. Thank you so much, Jasmine. And sorry, just the name again of that resource?
Yeah, so it's called the Probate Kit of BC.
Okay.
And it's actually by Mary Jane Wilson. And you can find it online on Amazon.
Beautiful. Thank you. And we can link to that when we put together the notes that go with this webinar recording. Thank you.
Definitely.
Our next question is also for you, Jasmine. When it comes to preparing court forms, do you need to have a lawyer to do it? What tips do you have if I want or need to do it myself?
No, you definitely don't need a lawyer to complete forms. You are definitely welcome to complete the process by yourself. And so if the matter is complex in nature, the registry would suggest you speaking with a lawyer to help better minimize any errors and any potential rejections in the future. So some tips that the registry here we can give to everyone would be that you should, if you are writing these documents out by hand, please write legibly. And when you're filling in these documents, our registrars are actually reading these documents. So if we can't read your writing, there's no way of us approving your application, just because we need to see the full names of everybody's spelling of their names. So please write legibly. That's going to be very helpful. Now, another thing we do require at minimum is a contact information of the applicant. So please, if it's an email address, please give us an email address so that if our registrars need to contact you, we have that mode of communication. If you don't have an email address, that's completely fine, but a phone number. That's definitely something we need as well if we need to contact you, and it's easier to talk over the phone as opposed to emailing you. Another tip I would definitely suggest would be to keep the names consistent throughout all your documents when you're submitting your application. The names in one document should match the next document, and especially if someone's name is listed differently in the will, as opposed to what their like legal name is or what they use in their everyday life, please make that clear to us in the application. You know, you can say named in the will as, because we can't assume that one person named in the will as one way is the same person as, say, the applicant that's applying, that's spelled in a different way. Further, please do not submit your documents unless all required documents are completed. And just make sure that you're stapling all your documents and keeping everything in an organized fashion. And so if you do make a mistake, it is completely fine because, of course, mistakes happen. You will be receiving a checklist from one of our Deputy District Registrars here. And the checklist usually will indicate very clearly as to what you have to resubmit. If they say, please file an affidavit in Form 109 to address something in, say, the P2 submissions, please just follow those instructions. It's usually very clear. They will have it in red or in bold at the bottom of each section of the checklist. Further, on the P2 schedule, in the P2 submissions form, just please remember to indicate whether or not the spouse, children, beneficiaries, or any intestate successors are surviving or if they're deceased. We do need to know the status of the particular person that you're naming in the schedule. And please do not leave anything blank. Everything is applicable in all of our forms, so we do not want to see a blank answer, basically. Please do not use NA or not applicable because, again, each section does apply. So the only way that it will be accepted is for us to see the words none or nil. So if there's no person, so say the deceased had no children, for example, just put none. Instead of leaving it blank, don't say non-applicable. And further to touch on that subject as well, when it comes to, say, the spouse, if there's no spouse of the deceased, please indicate by saying there is no surviving spouse as defined by Section 2 of WESTA. We want to see that line and not saying never married, just because that line there covers any common law spouses that the deceased may have. So just saying never married doesn't mean that they didn't have a common law. Further, another suggestion we will make would be on the P3 affidavit of applicant here. Just please remember to answer paragraph 2. What are you named as in the will? As executor or alternate executor, and the full name that's actually listed in the will has to match what is being listed on there. And because you are swearing to that affidavit, that has to be true. And a further tip that we can definitely suggest here is on the form P5. Please just remember to fill out which section of WESTA you're relying on. Just by stating you are the, say the relationship between you and the deceased, such as, oh, I am the spouse, it's great. That's good information for us to know in the registry, but we actually need to know the section of WESTA you are actually applying under. So that is very important and it's often missed. So please remember that. And last but not least, if you do need to, say, serve the PG&T, we do require the originally signed PGD comment letters. And that document needs to come in by itself. It cannot be exhibited. Please don't staple it to anything. We need that document in its original form. Yeah.
Beautiful. Thank you so much, Jasmine. That's such a comprehensive list of tips, right? Really practical tips that NA is not going to suffice. It needs to be nil or none, things like that will make sure that your application goes more smoothly. So thank you for that. Jasmine, this next question is also for you. I understand there's a requirement for a list of assets and liabilities, and what level of detail is required for that list?
For sure, definitely. So one thing to first note is that for the affidavit of assets and liabilities, there's usually 6 paragraphs in the body of in the, I guess, body of the affidavit, if you look in the forms online, just make sure you have all 6 of those paragraphs listed first of all. We need the full complete form. Sometimes paragraph 4 is missing, so we need every single paragraph listed in that affidavit that you're submitting. Now, moving over to the statement of assets and liabilities, the amount of information we need really depends on what kind of assets that deceased holds. It's usually, again, like what Jessica mentioned earlier, it's third-party asset holders that require, to require a grant. And so it's this document that we want to see where all your information are required. So if there's real property, we want to see if there's a PID. We also need to see the legal description and just any kind of account numbers. Especially if there is a mortgage attached to this real property, we need to see that CA number. In terms of, say, other tangible assets, if there's a car, we definitely need the VIN number. And any kind of assets, such as bank accounts, any form of identification number or account number is also required. And again, as previously mentioned, nothing should be left blank. So again, if a certain part in the statement of assets do not apply to the deceased, again, please don't leave it blank. Do not use NA or not applicable. You should answer that question by saying none, nil, or even 0. That's going to help us know that you didn't misdisclose an amount or just completely forgot about one section.
Beautiful. Thank you so much, Jasmine. Just out of curiosity, is that then a common reason why the application would be maybe delayed a little bit if there's nils, NAs?
Definitely, for sure. We see a lot of blanks or NAs a lot. So please just remember not to leave those blank. That's gonna definitely speed up your application when you do put nil or none.
Beautiful. Jasmine, this next question, again, is for you, and we're kind of peeking behind the curtain, what happens behind the scenes. So what happens after you file the court documents? How long will it take to hear back? And you've talked about this a bit already, but what happens if you make a mistake?
For sure. So once you file all of your court documents, the file will actually be placed in a queue, waiting for one of our DDRs to review the file. So it doesn't actually get reviewed on the spot when you file it over the counter, just because of all the backlogs and volumes. So the turnaround time really differs. Right now, we are in quite a busy season, so we're looking at around 9 weeks, but I think that's kind of shrunk down a couple of weeks down to about 7 weeks, I think, to 6. But because, again, due to the sheer volume, this might differ in weeks. It might be, a couple of weeks. Right now, again, we're kind of leaning on to the more longer side of waiting. But once the file is reviewed, though, and it has been approved, it would take roughly 3 to 4 business days for us to then finalize and then issue the grant. And it's okay if you make mistakes, because it's completely fine. Mistakes do happen. So again, when you do make a mistake, though, one of our registrars are going to send you a checklist, usually by email. If you don't give us a contact email address, then we'll have to mail it to you. This checklist or rejection list, it will outline everything that is wrong on your application, basically what you have to fix, the deficiencies. So please just read the checklist from top to bottom. And again, under each section of the checklist, usually our DERs are really great at explaining, okay, please file, a new affidavit applicant, or you can address your deficiencies by way of a Form 109, and just follow that instruction. The answers usually is on the checklist, and it's quite detailed. And yeah, I think what our DDRs would definitely prefer you to address your mistakes on a Form 109. We don't it just makes it easier for us because you're basically just answering the question in a Form 109, like question 1, question 2, and it just limits the amount of other mistakes that could occur if you were to say submit a whole new affidavit applicant or a whole new affidavit assets and liabilities, if that makes sense.
Beautiful. Thank you, Jasmine. And DDR, I assume that's
Oh, Deputy District Registrar, sorry, one of our registrars, yeah.
beautiful. So that's someone like you who would be reviewing, and I gather this Form 109 is then something that would supplement your original application with the corrections that have been requested from you or one of your colleagues.
Correct, yes. Again, when we one thing to also note is on our checklist, we'll have different sections outlining what needs to be corrected. Usually, if you see under the heading, say, please submit an affidavit in Form 109, and then you see that multiple times, it basically means you can just use one affidavit, swear one affidavit, and address all those issues in one affidavit. So it's easier for you, but also for us as well.
Excellent. Excellent. And I gather anybody who would have questions, like follow-up questions, would be able to contact the registry and receive guidance in terms of how to do that.
Definitely, yes. We definitely would encourage emailing us. Our email address is usually on the checklist or even in the email that we usually send out. And that's one good way to contact us. Yeah.
Excellent. I can imagine for some people, I've heard that for many people, the probate process is the first and possibly only time they engage with the court systems. And so there can be a certain level of almost intimidation. So I think just knowing that there are resources through the registries that can help support in the applications is really helpful. Jasmine, another question, and then we're going to turn it over to Jessica once again. I've heard that a probate fee or tax has to be paid to court. How does that work?
Yeah, so if your estate, the deceased estate, has a value of 25,000 or less, then there will be no probate fees due and payable. If it's anything over that amount, you will be charged a probate fee. So when the application or your application is reviewed by one of our registrars here, we will send you an email, regardless whether or not it's approved or not, if it's rejected as well. It will indicate how much your probate fees are owing. The fees are calculated based on the Probate Fee Act, and the Act does break down the calculation if you do want more insight on it. We do have a system in the courts here that automatically calculates probate fees, and just yeah, that will be basically outlined in both, say, your checklist and in the email that is being sent to the applicant.
Beautiful. Thank you very much. Jessica, this next question is for you. So we've gone through the process. We have our grant of probate. What is involved in dealing with debts and taxes?
So once you have the estate grant, you can transfer all of the deceased assets into your name as the personal representative of the estate. You would then essentially be holding on to everything for the estate. And the first thing you need to do is to settle the deceased debts and expenses, estate expenses. You will also need to file income tax returns for the deceased and for the estate. It's a good idea to talk to an accountant about this if you're not familiar with tax filings. You have to file tax returns for any year before the year of death if the deceased was not filing them annually during their lifetime. So, in previous years, every year we file our taxes, but if the deceased person was not doing that, you as the personal representative need to catch up on those tax filings. You also have to file the final tax return for the deceased, which would cover the deceased person's final income from January 1st of the year of death until the date of death. So that's the final tax return. And then there's also the estate return. The estate return covers all income in the estate after the date of death. So once all those taxes are filed, assessed, and paid, you can then apply for a clearance certificate from Revenue Canada, from CRA. And I would recommend, you should wait until you receive the clearance certificate before distributing the estate. If you distribute the estate to the beneficiaries before you've received the clearance certificate, and if you have not kept enough assets in your hands to pay those taxes, the personal representative, you may be personally liable for paying it.
Excellent. So you definitely want to have that certificate of clearance.
Mm-hmm.
Wonderful. Jessica, this next question is, what is the process for accounting to beneficiaries and heirs?
Yeah, so under the BC Trustee Act, before you distribute the estate assets to the beneficiaries, personal representative, so the executor or the administrator, is required to prepare a set of accounts to show all receipts, expenses, disbursements, and any payments in and out of the estate. These statement of account are generally presented to the beneficiaries for their approval. The Trustee Act says that you must formally pass your accounts before the Supreme Court within 2 years from the date the grant was issued, unless you have received consent from all the residual beneficiaries. So the usual practice is therefore not to have those accounts formally passed in court, but instead to have all the residual beneficiaries approve the accounts and to sign a release releasing you as the personal representative from any liabilities or claims with respect to your administration of the estate. The accounting should include details of the assets and liabilities of the estate at the date of death, which is essentially that P10, the affidavit that Jasmine was discussing earlier, the statement of assets and liabilities. The accounting should also include details of each receipt and disbursement during your administration of the estate, a list of assets that you have on hand now, and a statement of the distribution that you propose on making. If you are planning on claiming an executor or an administrator's fee, you would also include the fee you intend on claiming in that statement of account. For the beneficiaries to sign off on, for them to approve. If the beneficiaries do not approve the fee you're claiming, you would have to apply to the court to be awarded a fee.
Beautiful. Thank you. And Jessica, I'm going to ask you a question, a bit off our plan question, but you mentioned an executor and an administrator. I was wondering if you wouldn't mind just clarifying the difference between the two.
Yeah, no problem. So an executor is the person named in the will. So if there is a will and in the will it says, I name so-and-so as the executor, that's the executor, of course. The administrator, so if there's no will and you are a family member who wants to take care of the deceased person's assets in the estate, you would apply for an administration of the estate. It's called, it's quite similar to the probate application. You apply with the same form, with the P2 that starts the probate, the form P2 that starts the application to court. But instead of asking for the grant of probate, you're asking for a letter of administration without will annexed to say there's no will, but under WESA, you are somebody who's eligible to apply to take care, to administer the estate. So it's the personal representative of the estate if there's no will.
Excellent. Thank you so much, Jessica.
Yeah.
This next question is for Jasmine. Jasmine, what happens if I try to distribute estate assets to a beneficiary and I cannot find them?
So unfortunately, this would be beyond my jurisdiction. Unfortunately, the courts are no longer involved with the file once the grant has been issued. So you would need to speak with a lawyer if there are questions regarding the distribution of assets. Our role in the court stops once we issue that grant.
Excellent. Thank you. Putting you on the spot a little bit, Jessica, would you have a response to the question?
Yeah, so if you're not able to locate the beneficiary, I would say, you would want to make sure that the money is held back. I would, as part of the probate application, when you're applying for it for the probate grant, the estate grant, the notice the notice requirements would require you to notify any beneficiaries named in the will. And if you're not able to locate a beneficiary, that's something that you would have to deal with early on as well. In terms of the distribution of the estate, if there is money that is for that beneficiary, I would say to hold it back. Again, it really depends. I would say talk to a lawyer for legal advice in your specific scenario. But the money, if we don't know if the beneficiary is going to show up in the future and say, where is my money? And so it'd be prudent to hold that money back and keep that in the estate. But again, in situations like this where it's unusual, it's not a straightforward distribution, speak with a lawyer and get legal advice on the specific matter.
Excellent. Thank you so much, Jessica. I've got one last question for you, and then we're going to turn to the live questions. This question is, I've distributed the assets. How do I put an official end to my executor duties?
Yeah, so if you would like to put an official end to your executor duties, you can apply to the court for a formal discharge. You can only apply for the discharge if the accounts have been passed in court, the accounts we were discussing earlier, or if all the beneficiaries have consented to approve those accounts. A court order discharging the personal representative releases that personal representative from almost all actions, claims, and demands arising from the administration of the estate. So in effect, this is the same as having the beneficiaries sign that release I was talking about earlier. So this is why in most situations, a personal representative may not need a court order formally discharging them. For practical purposes, once a personal representative has completed their duties, they may not feel the need to apply for a formal discharge. In situations where maybe not all of the beneficiaries are able to sign that release, then maybe a formal discharge is something to consider to get the court to release you of any any liability and claims, future claims and actions.
Thank you to everybody attending and all the questions that we had. This is really excellent having these questions that have come in. I am triaging the questions based on upvote and also looking at the questions that are most closely tied to today's topic. So thank you, everybody. I'm going to pose, I think this is probably a question for you, Jessica. I am a named executor. One of the beneficiaries in the will is a non-resident of Canada. When dispersing estate funds to this beneficiary, are there any tax considerations if their country has an income tax convention agreement with Canada?
Yeah, so I'm not a tax lawyer. I'm not an expert in taxes. There may be withholding taxes that might apply. If you're not sure, talk to an accountant to make sure before you distribute anything. Again, the clearance certificate, all of those tax, if it's anything that's out of the ordinary, non-residence involvement, I would say get tax advice before you distribute anything.
Excellent. Here we have a question. One of the beneficiaries has Alzheimer's and has a power of attorney handling her affairs. Can I send notice to the power of attorney?
It depends. If it's a power, if it depends on you can sign, the notice, I'm assuming you're talking about the probate application, the notice for the probate application. The public guardian and trustee will likely have to be notified. All the rules in terms of when the public guardian and trustee needs to be notified, if you go look at the Supreme Court rules, Rule 25-2, I believe. Yeah. So you go through the list of the people that need to be notified, and it tells you if there's somebody who may be mentally incapable, or have a legal disability. It explains to you who needs to be notified. If there is a personal representative of the person, that person may be notified. The public guardian, just depends on the situation. And so I would say, go look at the rules. It spells out exactly who needs to be notified given different circumstances.
Beautiful. Thank you so much, Jessica.
Yeah.
Jasmine, this next question is for you. And there's a question from the Seashell Library. Can you please tell us more about that probate kit that you mentioned? I think this will be helpful for anyone who's looking for a resource to help support them through this process.
I wish I brought my copy in today with me. And so on the other side, but it's basically a book. It's literally called the Probate Kit. has very detailed information as to, it gives you definitions as to who's an executor, administrator. It even actually outlines what beneficiary is and who intestate successors are, from the list of priority, who gets, top priority, to someone who has the lowest priority. It basically touches base on a lot of things that, if you are submitting a probate application yourself without a lawyer, it's very useful. We do direct a lot of our clients to get this resource online. Again, I believe it's on Amazon, and we basically have a copy here that we often do show a lot of our clients. And I think especially for a library, I believe, I think Paul, you said it was from the
It's
Seashell
from the
Library.
library.
Yeah, if you guys can even get a copy, that would be really useful for clients who are trying to get through this probate process, which is, it's definitely challenging. So that book is very useful, in my
Beautiful.
opinion. Yeah.
Thank you so much, Jasmine. I think it's a great idea. Jessica, this next question I think is probably in your domain. There are two co-executors, oh dear, and one alternate executor named in a will. It's in the early stage of preparing for probate. Both the co-executor and alternate are considering renouncing executor positions. If this occurs, can the remaining executor proceed to probate, or is the estate handed over to an administrator?
Yeah, so if there is a valid will, and there are two co-executors, if one of them decides they are not going to be the executor, they can renounce. And like I said, as long as they have mental capacity to sign a document that says they're renouncing, the other executor who is remaining can apply for probate, and they would file along with the probate application a court form. I believe it's P17.
P17.
P17, which is the notice of renunciation. So that renunciation would be signed by the person who is named but renouncing. And then once that is filed, then the remaining executor, or the remaining of the co-executor can continue on. The alternate executor does not have priority over the co-executors in most situations. Again, depends on the will, but in most scenarios, usually they're called an alternate because they only have authority if the first two people named, neither of them are acting, then the alternate has authority. So generally speaking, if there are two co-executors, one of them renounces, the other will act on their own. Depends on the wording of the language in the will, but that's generally the case.
Excellent. Thank you so much, Jessica. Jasmine, this next question is for you. How long does a probate application take to complete? And by this, what I think is being asked is that actual paperwork. Like if you were to go through the paperwork start to finish, do you have a sense of what the average time would be?
For one of our registrars to check the file?
I think for actually preparing, how long does the probate application take to complete? So I think that would mean gathering the forms, completing the forms. Do you have
For someone who is trying to fill out the documents, you
I
mean?
think so.
And I won't be able to say, just because again, every application is different. So depending on how complex, and if there's a will involved, it depends on how fast you're able to gather all the information needed and required. Yeah, I just don't think I'm able to.
Yeah, and I think, Jasmine, you're right. I'll add on to that. I mean, the forms themselves are quite, they give you directions as to how to fill them in. They're not the most difficult to fill in if you follow instructions. I think that the part that takes the longest is gathering the information. So for that P10, the affidavit of assets and liabilities, finding out the bank accounts, the account numbers, and all the details that are required for filling out that form, that usually takes the longest in my experience. So, asking banks for the date of death balance, figuring out if certain assets need to be appraised, getting the appraisal for those assets, that is the part that takes the longest. Yeah, that in my experience anyways.
Beautiful. Thank you. Jessica, I think this question would probably be for you. And it's about when a person dies, I gather it's not possible for their enduring power of attorney to access funds to pay a care home bill, for example. Is that right?
Yeah, so that's correct. The power of attorney terminates upon the person's death. So it's no longer, if you cannot act on a power of attorney when someone has passed away. The care home bill, if you're the executor and you're acting as the executor, you decide to go ahead with that. If there's a care home bill that needs to be paid, you can take the bill directly to the deceased person's bank and ask them if they will be willing to issue a bank draft or a check to pay that care home bill. Depends on the bank. You would have to ask them to issue the draft or the bank draft straight from the deceased person's bank account. Some banks will do it, some banks won't. If you, the executor, pay out of pocket first and then ask the bank to reimburse you, chances are they're going to say no until you get the probate grant, the estate grant.
Beautiful. Thank you, Jessica. Jessica, I think this is another question that would probably be in your field. I want to appoint my only daughter and my only son as the executors of my will. My husband and I have always treated them equally and want this to continue. My daughter lives in BC and my son lives and works in the UK and so is a non-resident of Canada. Is this non-resident status a problem when it comes to taking my estate to probate? If so, how can it be resolved?
Yeah, so you are allowed to appoint whoever you want as your executor, right? So you would be able to appoint your son and your daughter as co-executors. The non-resident status would potentially cause tax issues. The estate, like I said earlier, your estate, the executor files tax returns for the estate, and so the estate is a tax. It needs to file taxes for the estate, and the tax residency of the estate is determined based on who is controlling the estate. So if it's a non-resident executor controlling the estate, that estate could potentially be considered a non-resident estate. These are tax questions. Again, I'm not a tax expert and I can't give tax advice or provide any tax information either. So in the estate planning side of things, I know this is more a probate conversation, but when I prepared estate planning documents for clients, sometimes we consider the residency of the people you're appointing as executor. You could also appoint both of them, and then, again, the renunciation is always an option. Sometimes people appoint their children while they are BC residents, Canadian residents, and then they move away and years later. The renunciation would be an option, right? Asking for tax advice, making sure that the tax implications, consequences are not adverse. If they are, then maybe one of them can renounce. The non-resident executor could renounce and allow the resident executor to act. These are all different possibilities. And if there's any uncertainty, again, talking to a lawyer, getting the appropriate tax advice is always the way to go before appointing any, in the scenario, appointing the non-resident.
Beautiful. Thank you so much, Jessica. Jasmine, this next question is for you. It's very specific about one of the forms. For P2 original will plus 2 copies, do simple photocopies work or do the copies need to be notarized?
Oh, just two of the photocopies would be fine. We just need a clean, the photocopy must be an exact photocopy of how the will looks like. So don't write copy, don't stamp the word copy on the copies of the wills. We need it exactly the same as how the actual will looks like that's being submitted.
Excellent. Another technical question. Currently applying for an estate grant, but the original will was never stapled. It had a plastic spine that has been taken off. Should I proceed with the P4?
I don't want to dive into any kind of legal advice or giving any. If you feel like you need to use that P4 affidavit applicant and explain, then please do. I don't want to, again, I don't think it's my jurisdiction to say yes or no at this point.
Absolutely. And a reminder for all of our guests, I mean, the information that we're providing today is information. It's not legal advice in the sense of it being advice that is responsive particularly to particular fact situations. So appreciate that. Thank you, Jasmine. I'll ask this question, and again, if it's problematic, let me know. The notary misspelled the name on the will, mixing an R and an O in the last name. First and middle names are correct. The beneficiary name is correct, and the will was witnessed correctly, but no one caught the spelling mistake. Will this be a problem? The person whose will it is can no longer make changes because they're very ill.
Is this okay? Yeah. Yeah, no problem. There are ways to cure a will. So if it was valid for all other intents and for other reasons, everything else is proper and properly executed. There are no issues with the will, and it's just a matter of a clerical error. There are ways to apply for a court order to fix this issue. You could refer to Section 58 and Section 59 of WESA, Wills and Estates Succession Act. Section 58 and Section 59 are those curing provisions in the legislation that allow for certain, not all, but certain mistakes to be cured by a court order.
Excellent. Thank you. Another question here. We have not found a will. So how do we say that in an application for a grant of administration?
Yeah, so again, it's when you're applying for the estate grant, there are affidavits that need to be filled in. And so if there's no will, you would do a P5. The affidavit is in Form P5, and you just go through the form and fill in your answers. There will be, again, instructions about what you need to include, what reasons, and it says basically that you've looked everywhere you're supposed to look, you've done a diligent search, and you're satisfied that there's no will, that there's no testamentary document or record of any kind left by the deceased, and then you sign that affidavit to apply for the administration grant.
Beautiful. Thank you. Maybe we probably have time for maybe 2 or 3 more questions. I've got a question here, Jessica. This is probably a question for you. Is a grave site a tangible asset?
That's a good question. In my experience, most grave sites are not legally owned by the person who has passed away. It's usually an interest, a right to that grave site. If that's the case, then it's not a tangible property. If it's the land that is owned, then it would be a tangible property. I would say look at the documents, the contracts that made you think that this deceased person owned the gravesite. Look through those documents and figure out if it's the interest, it's the right to use that piece of land, or if it is the land itself that is owned by the deceased person.
Beautiful. Thank you, Jessica. Jasmine, I think this might be a question for you. Is the applicant's personal contact information in court documents protected, or is it available to the public?
If you've written your contact information on the P2, it would be, the document usually are scanned in. So anybody who is a party, I believe, to the matter can access through CSO if you do have an account. But most often, we just really require just an email address. You don't have to put your you don't need to put your full address on there. The contact information is really for us to contact you, the applicant.
Excellent. Thank you. And one last question, and I'm going to have to paraphrase because I can't find it anymore in my dialogue box. But Jessica, this is a question for you, which is if the executor has created the list of assets and liabilities and the beneficiaries would like to have access to it, are they entitled to receive a copy of it?
So the executor has a duty to provide accounting anyways to the beneficiaries, right? So like I said earlier, as part of the accounting, the statement of assets and liabilities would be disclosed in the statement of accounts anyways.
I'm just going to ask our guests a couple of takeaway questions. So, Jessica, I'll start with you. I'm just wondering if there's anything that, in going through today's webinar, you thought, okay, here's something else that I'd like to add, or a theme, or something that kind of came of note to you as we were discussing.
Yeah, I think the main thing about being a personal representative is to just try to stay as organized as possible. There's a lot. It can be overwhelming, especially during a time of grieving and loss. I think staying organized is one of the main tips I give to clients, to executors, is to make sure that you're keeping track of everything from the get-go, from the very beginning. The administration process, the administration of the estate can take quite some time. You could be dealing with the estate still a year later, and so you might not always remember all the expenses and disbursements that you've done in the first month or in the first week.
Beautiful. Do you have any sort of examples of how you might do that? A folder, a physical file on your computer? What kind of tracking mechanisms have you found to be effective among your clients?
Yeah, I mean, it depends. I have a lot of people who use just an Excel sheet, a spreadsheet to record everything, um, because the statement of accounts that need to be prepared at the very end usually is in the format of a spreadsheet. But if you're not familiar with using, Microsoft Excel, you could even just handwrite it. I also have people just keeping a notebook of all the things that have happened, all the expenses and everything, just making sure that it's recorded in a way that you're comfortable with.
Thank you so much, Jessica. I find whenever I try to rely on my memory, it's not it's not the most reliable. So having a system, a hard copy of all that information is really helpful.
Yeah.
Thank you. And Jasmine, thank you so much for joining us today. It's been so helpful to hear your perspective from the registry's perspective. All those tips about how to complete those forms were really, really, really valuable. Similar question for you, Jessica or Jasmine, as we wrap up today, any thoughts that you have in terms of tips for anybody who's going through the process, or something that we didn't talk about that you would like to mention?
If you were to make a mistake and you receive a checklist, to just really follow the checklist, because a lot of the answers are almost right there in front of you on the checklist. So just read it from top to bottom and really just try to understand it and answer the question that's being posed in that checklist. And I think that would be most useful and helpful.
And with that, we are at time. And so I just wanted to say thank you to you, Jessica. Thank you to Jasmine. You have answered so many questions today, and the information you've shared is so practical.